Across the UK right now, councils are draining bank accounts, garnishing wages, even threatening prison, all without a proper court judgment. Sound lawful to you? Well, it's not. Because the 1992 Local Government Finance Act, yes, the one that introduced council tax, never gave them the power to enforce like this. No debt class, no bypassing courts. So how are they doing it? Through minister-written regulations, not full acts of parliament, that sidesteps centuries of constitutional protection. Quiet, undebated, unchallenged. But here's the shocker. These regulations convert a statutory duty into a so-called debt, without trial, without judgment, without your chance to fight back. If you've ever been told that's just how it works, it's time to question everything, because this isn't just bad policy, it's a legal illusion, and your rights hang in the balance. In the next few minutes, I'll break down the truth behind council tax enforcement, what the law actually says, and how your rights may have been steamrolled by administrative shortcuts. So, if you think due process still matters, you need to hear this. The Local Government Finance Act 1992. What it did and didn't do. The Local Government Finance Act 1992 created council tax. But despite what many assume, it did not create a new class of debt. It did not authorise councils to enforce liability outside of court judgment. This is not new. Over a century earlier, Parliament had already made clear the limits of council powers. The Local Government Act 1888, Section 78, subsection 2 states, "The transfer of powers and duties enacted by this Act shall not authorise any county council or any committee or member thereof, A, to exercise any of the powers of a court of record, B, to administer an oath, or C, to exercise any jurisdiction under the Summary Jurisdiction Acts, or perform any judicial business, or otherwise act as justices or a justice of the peace." In other words, councils were never intended to perform judicial functions. They were not granted the powers of courts, and they were not authorised to impose punishments or forfeitures without judicial process. Section 79, subsection 2 of the same Act also says all duties and liabilities of the inhabitants of a county shall become and be duties and liabilities of the council of such county. This raises important constitutional questions about whether councils, as corporations, can inherit individual legal liabilities at all. But that's a conversation for another time. For now, it should certainly trigger some serious doubts. The problem today: council enforcement without judgment. Today, across the country, councils are enforcing payment as if a judgment had already been made, leading to wage deductions at source by employers, enforcement agent visits, bankruptcy proceedings initiated without a proper judgment debt, charging orders placed on property without adjudicated judgment, as well as threats of imprisonment, despite no lawful authority for arrest. The question is simple. Did Parliament ever legislate to give councils and the public servants who serve the people that kind of power? And if not, where does it come from? Let's look at what the law actually says and what the Constitution actually allows. Here's what the LGFA 1992 legislated and what it didn't. The Local Government Finance Act 1992 is clear. It creates a liability to pay council tax for those occupying or owning property. Section 6, subsection 1 of the Act states, a person is liable to pay council tax in respect of any chargeable dwelling. This is a statutory liability, a legal obligation to pay, but nowhere does the Act define that liability as a debt, and it does not grant any new enforcement power that overrides constitutional protections. There is a vital legal distinction here. First, a liability is a duty created by statute, and secondly, a debt is an enforceable obligation confirmed through independent judicial proceedings resulting in a judgment. If Parliament had intended to create a new enforceable debt class, bypassing courts and constitutional rights, it would have said so. But the LGFA is silent. It creates a duty to pay, not an automatic right to enforce without due process. The unlawful enforcement regulations. The enforcement powers that councils rely on today do not come from the LGFA 1992 itself. They come from something else, a statutory instrument, a form of secondary legislation. What is a statutory instrument? It is not a full act of Parliament. It is not debated or voted on by MPs. And it is a regulation written and signed by a minister under delegated authority. In other words, Parliament did not directly authorise these detailed rules. Ministers created them later, often with little or no parliamentary scrutiny. Statutory instruments are supposed to be used for minor administrative matters, but in this case they created an entire enforcement mechanism affecting property, wages and liberty itself. That instrument is called the Council Tax Administration and Enforcement Regulations 1992, and it's these regulations, not the LGFA itself, that councils rely on to seize money directly from wages, send bailiffs to seize property, apply for bankruptcy, place charging orders on homes, and threaten imprisonment. Inside those regulations, two particular rules stand out, Regulation 49 and Regulation 50. And it's here that the most serious constitutional issues arise, because these regulations don't just administer council tax collection, they attempt to convert statutory liability into enforceable debt. Regardless of intent, the effect of these regulations is to bypass the constitutional and legal protections guaranteed to every subject of the realm. Let's examine them carefully. Regulation 49, creating a fiction of debt. Once a liability order has been obtained through the Magistrates Court, an administrative court, not a court of record, Regulation 49 comes into effect. Regulation 49, subsection 1 states, where a liability order has been made and the debtor is an individual, the amount due shall be deemed to be a debt for the purposes of Section 267 of the Insolvency Act 1986. This is a critical legal device. It means council, having obtained a liability order without a full judicial trial, can now treat council tax liability as an enforceable debt purely for the purpose of presenting a bankruptcy petition. And that petition is made in the county court, not the Magistrates Court. A wholly different jurisdiction, one intended for genuine civil disputes with proper judicial process. The Magistrates Court normally deals only with minor criminal offences, not the creation of civil debts. So I'm sure the creation of an entire regulatory system designed to bypass the constitutional protections of the county courts was simply an accident. Because under Section 267 of the Insolvency Act 1986, a creditor must prove a liquidated debt, one ordinarily established through proper judicial proceedings and a civil judgment. Given how clear that requirement is, it raises serious questions about how such a regulatory bypass could ever have been permitted. But Regulation 49 sidesteps this with no independent judicial adjudication, no adversarial hearing, and no lawful judgment by a court of record, thus no civil judgment confirming liability, no adversarial trial, and no opportunity for proper defence. Instead, an administrative liability order is treated as real debt and used to bankrupt individuals. This raises profound constitutional questions because bankruptcy, a form of civil death, carries devastating consequences. And under English law, such consequences must arise only through lawful judicial judgment, not administrative shortcut. Regulation 50, charging orders without real debt. Regulation 50 escalates the enforcement even further. Just as Regulation 49 creates fiction for bankruptcy, Regulation 50 creates fiction for property seizure. Normally under the Charging Orders Act 1979, a creditor must have a proper court judgment before seeking a charge over property. But Regulation 50 circumvents that because councils can apply for a charge based solely on a liability order. No civil trial takes place and no adversarial testing of evidence occurs. This is not due process. It is regulatory conversion of liability into enforceable debt by ministerial regulation, not an act of Parliament. And these facts raise serious concerns about the lawfulness of the enforcement process and its compatibility with our constitutional and human rights protections. The constitutional and human rights breach in council tax enforcement. This power was never legislated by Parliament. It was created through secondary legislation, not by a sovereign act of Parliament as constitutional law requires. It bypasses critical legal safeguards with no trial, no judicial determination of fact, no opportunity to challenge liability, and no compliance with the standards of the Insolvency Act or Charging Orders Act, and it violates both historic and modern protections. Our historic constitutional guarantees include Magna Carta 1297, no free man shall be taken or imprisoned or dispossessed except by lawful judgment. The observance of the Due Process of Law 1368. No property or liberty may be taken without lawful due process. The Bill of Rights 1688 forbids the creation of fines or forfeitures without the consent of Parliament, and under modern law, Article 6 of the European Convention on Human Rights guarantees every person the right to a fair and public hearing by an independent and impartial tribunal established by law. Through the Human Rights Act 1998, these protections are directly binding in the United Kingdom, yet liability orders granted without trial, without testing of evidence and without true judicial scrutiny do not meet the standards required under Article 6. No regulation, however convenient, can lawfully bypass these constitutional and human rights protections. Enforcement and the law of debt. What's missing? Even under modern statute, lawful enforcement must follow proper structure. Under the Charging Orders Act 1979, a creditor must have a court judgment debt before seeking to charge property. Under the Insolvency Act 1986, sections 267 and 268, bankruptcy must be based on a liquidated proven debt through the courts. Yet liability orders are issued without trial, are granted in bulk, involve no adversarial hearings, and involve no real judicial inquiry. Thus, when councils use liability orders to pursue bankruptcy, charging orders, or property seizures, they may be bypassing both statutory protections and fundamental constitutional principles. This exposes the entire council tax enforcement system to serious constitutional challenge. Final thoughts. What this means for you. The Local Government Finance Act 1992 did not give councils a blank cheque. It gave them a duty to collect tax, not the power to bypass the Constitution or human rights law. You cannot lawfully be stripped of your income, your home, or your liberty without due process of law. If you are facing enforcement, remember, ask to see a court judgment, not just a liability order. Demand due process, not regulatory shortcuts. Stand on your constitutional rights and your human rights under Article 6. And finally, challenge anything that goes beyond what Parliament actually authorised. Knowledge is power. Use it. Defend your rights. A word to public servants and solicitors. If you are a public servant, a council officer, or a solicitor involved in these proceedings, you too are bound by a duty to uphold the law, the Constitution, and the rights of the people you serve. You cannot, in good conscience or law, continue to enforce regulations or procedures that you now know bypass constitutional safeguards and due process protections. Knowledge creates responsibility. To knowingly continue enforcing unlawful practices once aware of these constitutional issues is not simply wrong, it may amount to misfeasance in public office, or for solicitors a breach of professional duty to the court and to justice itself. But beyond human law, there is a higher law, the law of conscience, the moral compass that every individual carries within them. Throughout history, those who blindly obeyed unlawful commands have been judged not only by courts, but by the deeper tribunal of conscience, and ultimately by God's law. Today, the world is changing. Each of us must decide on which side of truth, law and morality will we stand. You were never given authority to act above the Constitution, nor freed from your higher duty to do what is right. Your role is to uphold justice, not to circumvent it. The people you serve and your own oaths of office demand no less, and so does your own conscience. In conclusion, the Constitution still reigns. So, now you see, The enforcement mechanisms used for council tax aren't just flawed, they cut straight across centuries of constitutional protection. This isn't just legal overreach, it's a violation of the foundations that protect every one of us. And to be clear, this isn't about avoiding obligation, it's about refusing to surrender rights bought with blood, law and centuries of struggle. Because due process isn't a formality or a privilege, it's your birthright. It's a shield every citizen is entitled to, and that no regulation can lawfully take away. If this message resonated with you, or even made you think twice, please give it a thumbs up. And of course, be sure to subscribe so that you don't miss any new content. Most of all, please share it with someone who needs to hear it. Together, let's remind them the Constitution is not optional. It's supreme. Follow, learn, share, stand. This video is for educational purposes only. It is not legal advice. You should seek professional legal counsel before acting on any information presented.